we'll deal with a new topic under Sale of Goods Act, that is conditions and warranties. What are these conditions and warranties? Well, it is given under Sale of Goods Act. First, before knowing what is condition, what is a warranty, let us try to know what is stipulation. From this word stipulation, we'll get to know what is the meaning of condition and warranty under Sale of Goods Act. Stipulation, you come across this word when you are studying about conditions and warranties. Stipulation means a need or a requirement. You are buying certain goods. And what is your requirement for that? Why are you buying it? Suppose you are going out with your friends, somewhere outstation. So you are purchasing a camera. You are purchasing a very best camera in the market with a high resolution. So your purpose is to get good pictures with a high resolution. So that is your need. That is your requirement. You are buying a phone again. You are buying it for, you are going out somewhere and you want a best selfie camera or a best camera in the market. So what is your need? Your need is, you need a very good camera which is very good in the market, best in the market. So that is your need or requirement. Clear with this? So stipulation means need or requirement. So as soon as you hear this word stipulation, the first thing has to come is, what is the requirement? What is the need? You're buying a goods. Fine. After understanding the meaning of stipulation, we will get to know what is condition and warranty. Condition means it is one of the essential to the main purpose of the contract. So, why are you buying this product? You're buying certain products. Why are you buying this chalk paste? In order to write on a board. So that is your main purpose. Why are you buying a pen? To write in an examination, write neatly in an examination. So that is your need, that is your main purpose. The stipulation or the need under condition is what? That is a main purpose of a contract. You are buying this product for the main purpose. You are buying a camera, since you are going out of station, you need a camera, right? So you are buying this for taking good pictures, a best high resolution camera. So that is your primary purpose, to take beautiful pictures. If at all that purpose is not served, then the very much buying of that product would be failed. Like, why did you buy it? It is for your requirement, the basic requirement. So condition means essential purpose. It is essential to the main purpose of the contract. So this is given under section 12 of your Sale of Goods Act, and the definition of condition is given. So what are the effects of breach now? So the effects of breach of main purpose of the contract is, you can repudiate the contract. You can refuse it. You can say, no, I won't continue this contract because the very purpose of buying this product is not fulfilled. I have brought this chalk paste and it is not writing on the board properly. Then the very purpose of buying this is defeated, right? Why did I take this? That is why the main purpose is not fulfilled. Then you can repudiate. You can say, no, I don't want this. Or else you can even reject the goods. You can say that these chalk pieces are not good, I am going to reject it. Or else you can ask for a refund also. So whenever there is a breach of the main purpose of the contract, you have three options. That is, one is right to repudiate, reject, or refund the goods. Clear? Refund for the price. You can ask for the refund for the price. Now, after knowing the conditions, now let us discuss about warranty. What is warranty? What do you mean generally warranty means? When you buy things, they say we give you guarantee and warranty. What is warranty? Warranty means, it means first, if there is any damage or defect found in your goods, if it is covered under warranty period, they are going to first try to repair it. If at all you cannot repair it, then they are going to replace it. But if it is covered under guarantee, immediately, as soon as the product, you find that the product is defective, immediately it will be replaced. That is the difference between guarantee and warranty. Now here, coming to warranty, the stipulation, the requirement or need is collateral to the main purpose. It is not the main purpose. Main purpose is something else, and it is collateral. In the sense, it is secondary. It is not a primary purpose. Clear with this? So you are buying a phone now. You are buying it for camera. You want a best camera, and it has got certain additional features which are really good. Those are not your main purpose now. The main purpose, you bought it for camera. Those other things become, it is the collateral purpose. That is a secondary purpose. So, in case of effect of breach of warranty, what is the remedy available for you? If there is a breach, you can claim only damages. So, you have got a camera and there is slight damage in the phone. You got a camera phone to take selfies and there is certain damage in the phone which you have not noticed. So, now you can claim for damages for it, or you can only claim damages but not repudiate or reject the goods. Here you had an option of repudiating and rejecting the goods, but here you can only claim damages and no repudiating the contract or no rejecting the contract. So I hope you are clear with the conditions and warranty. So remember, three important things to be remembered when you are speaking about conditions and warranties is, first term, wherever you are discussing about condition warranties under Sale of Goods Act, first thing that comes to you is stipulation. Stipulation means need or requirement. Under stipulation, you get condition and warranty. What is condition? It is a main purpose of the contract. Warranty is the collateral purpose of to the main contract. Clear? From this you can get to know when the main purpose itself is breached, you can repudiate, you can ask for refund, or you can reject the goods. But whereas the secondary purpose for which you have bought it is there is a breach, you can only claim for damages. You cannot repudiate or reject the goods. Now, after knowing about conditions and warranty, can the condition be treated as warranty? When are those situations? Let's discuss. So, when condition to be treated as warranty? Under these conditions. The first one is when buyer, that's given under section 13, one more important part to be noted, when buyer waive the condition. So, if the buyer himself says, okay, let me waive off, he surrenders, he is giving up, that fine, okay, whatever has been happened has happened, I will waive off the condition. I have got it for some important purpose. Suppose I have got blue gel, I have ordered for blue gel pens and I got blue dot pens with a refill ink. Now, since I have got it, I being the buyer say, okay, fine, I've got this, I'm okay with this, I seek the sell. What am I doing? I'm giving up my right. What was my right? To get that particular pen, but now I've got different pen. So I'm waiving, I'm surrendering, I'm giving up the condition. What is condition? My main purpose. What was my requirement? I wanted blue gel pens, but I've got dot pens now. So I'm giving up my condition. So what are the effects? What happens is the buyer loses the right to repudiate the contract. He cannot cancel the contract, even reject. Now, as the buyer is accepting it, can't even reject it and cannot ask for the refund also. These are actually given under subsection 1 of section 13. Yeah? Okay, now we have got to know the first condition where the condition is being treated as valid. The second one is when buyer elect to treat it as a treat the condition. When he himself treats the condition as warranty, then it be considered as warranty. Okay, I'll give you an example for this and you'll understand in a better way. So, I have a wheat in my godown. There is one person who makes a contract with me to supply high grade quality of wheat. He wants high grade quality of wheat, which is 800 rupees per bag. That person orders for 10 bags. I want high grade quality of wheat and I want it, whatever is the amount, that is the 800, that is 10 bags I want. Then what I do is, I deliver him medium quality wheat. I don't give him that high grade, I deliver him medium grade. Now the buyer says, okay, fine, since I have got it, I have delivered, I have given everything, everything is done. Now fine, I'll accept it, but please see to that, I have given you 800 rupees per bag, right? Now you have to reduce 100 rupees from the amount. So thereupon we agree that fine, I will be reducing, the buyer will be reducing 100 rupees, which was 800 rupees, the buyer is going to pay 700 rupees and he will be accepting the medium quality wheat. So thereby what is he doing? He is electing, okay fine, I will take this. Now what happens? What are the effects? Same as this. Clear? Same. He is not able to repudiate, he cannot cancel because he has agreed. He cannot reject the goods because he has agreed. Fine, okay, I will be buying the medium quality wheat itself. Then refund also. It is only some amount of reduction he is asking. That's all. The next one is when the contract not severable. Severable in the sense, you cannot make it into different. You cannot separate it. We'll take an example for this. Now, there is a person A who makes a contract with B for supply of concrete. So concrete has various ingredients, cement, then there are some small stones required for that, and also mud, right? So there are various ingredients. The buyer says that you please supply me high grade quality of cement. The concrete should have all high grade quality. Whatever the ingredients you mix, it should be high grade. It's okay, if the price is high also, I will pay. Now the seller, what he does is, he gives a low quality or not a fine quality of cement. He mixes, he makes a concrete and he delivers 100 bags to the buyer. And when they are actually doing the construction work, the cement is not strong and there is some damage there. They get to know that the cement is not of high grade quality, it is a very poor quality or a very low quality one. Now, since this concrete what he has made, can it be severable? Can it be separated? The concrete is made of different things, right? Cement, mud, stones and all. Can you separate it? No, right? It is not severable. So, in that condition, under this situation, the condition becomes warranty. And no repudiation, no rejecting the goods also, and no refund also in this question. Clear? Why? Because no repudiate. Because now they cannot do anything. Clear? So it becomes, condition becomes a warranty. The next one is, nothing shall affect the breach of condition or warranty, impossible or otherwise. So what it says is, if there is a breach of condition or warranty due to impossibility of performance. In the sense, I have ordered certain stationery products. And there is sudden heavy rainfall and flood all over the state. It becomes impossibility, right? They can, the supply of stationery cannot be done. So what is it? Impossibility of performance. Or otherwise, in the sense, now we had a curfew in the month of March, April and May. So because of that, it could not be delivered. So nothing shall affect the breach or warranty in such a cases where there is an impossibility or any otherwise, in the sense there are some other factors which makes it impossible. So there is a brief, in case if at all, then there is a breach of condition or warranty. So under such situations, you can treat condition to be warranty. When the parties, that is when the buyer and the seller, when they enter into a contract of sale, in they do have certain agreement which have been expressly made by them. They would have certain conditions or warranties in the contract. Apart from this, you can find certain other conditions which are provided in the Act. Those are called implied conditions, which are put down by the Act. So these conditions, this implied conditions and implied warranties, which are given by the Act itself. So those are given under section 14 to 17 of Sale of Goods Act. So section 14 to 17 impliedly there in every contract of sale of goods. It is implied in every contract of sale of goods. What are those implied conditions? I told you implied conditions and warranties. But before going to warranty, let us see what are those implied conditions. The first implied condition is implied condition has to the title. That's given under section 14 subsection A. So in every contract, the seller has an intention to sell his goods to the buyer. If there is any other intention, well, it has to be shown. But what is his main intention? He has to sell the goods. So either the owner or his authorized agent can sell the goods to the buyer. So before the sale takes place, what is necessary? There should be a good title, right? The person who is selling should have a good title so that he can sell the goods to the buyer and the buyer also get a good title for those goods. So that is what is title. Implied condition has to the title, means there has to be a title to the goods to the seller so that he can sell it to the buyer. In case if there is no title to the goods, then what to do? Then what can buyer do? Buyer can the buyer has a right to reject those goods or claim back the amount in case he has paid, or also refuse to pay. In case if it is not paid, he can refuse to pay if there is no proper title to the goods. So what are the three remedies available to him? Right to reject, right to ask for the claim, and right to refuse to pay. These are the three remedies available under this implied condition has to title. To understand this better, we have a case law. The first case law is Roland versus Diva. In this case law, the plaintiff purchased a car from a defendant. This plaintiff, after purchasing, he used it for several months. And after using for several months, suddenly a person comes and he says that he is the true owner of the car and the defendant did not have a title to the car itself. Thereby now the plaintiff had to return the car to the true owner. Since he has paid the money to the defendant and then purchased the car from the defendant, now he files a case against the defendant asking to give him his money back. So it was held that the defendant was liable to give money and plaintiff can recover the money because the consideration for the use of car had totally failed. When he has got no title itself, how can he sell it? How can he pass on the good title to the seller? He can't sell it. So that was this case wherein the defendant did not have a good title. The next case, okay, before starting the next case, if the goods bear the label, almost all the goods, when you purchase a pen or pencil, you can see a label. If those goods bear a label infringing the trademarks of third person, the seller has no right to sell the goods. Even those are the title, right? When you are having a product, when you are buying a product, seeing its label, even that is also a good title to the goods, right? The seller is having a good title to the goods. So in case if he does not have a good title, he cannot by infringing the trademark. For that we have a case law, another case law, Implied versus Confectionaries Material and Company. Then this case is very important. We will be repeating this case again in implied warranty also. First, when it comes to implied condition, let's see what happened in this case. There is a person's seller. He sells the goods to buyer. What are those goods? It is a tins of condensed milk. and that is from New York to London. And on the tin, there is a label of Nestle brand. It was the trademark of Nestle company. It had a label of Nestle brand and label of Nestle company, and the seller did not have any right to put that label on the tin. This Nestle company gets to know that they are infringing and they are selling it. They inform to the Commissioner of Customs, and the Commissioner of Customs detained the goods when it was reaching the destination, when it was about to reach the buyer. Now the buyer, he was forced to remove the labels and also sell it before taking the delivery. He was forced to remove the labels and take the delivery, and since he had removed it, he suffered losses by selling without proper labels, and moreover he sold it at lower prices. Now this buyer filed the case against the seller, claiming compensation for the damages, since there was a breach of what? Condition, the main purpose. So hence the seller was bound to pay the damages, whatever the loss suffered by the buyer. Clear with this? Okay. So in this case, they are infringing the trademark of a third person. Even the trademark becomes a title to the goods, right? So when it is concerned to the title, there should be a good title. From this you can get to know. The next one is, the next implied condition is implied condition in sale by description. What is this description? Description means particular class which describes what a particular class or a kind of goods or statement essential to identify the goods has contracted between the parties. So, for example, it can be a quality, it can be fitness, it can be even place of shipment, it can be the time of dispatch of delivery, or time of shipment, mode of packaging, etc. So, the description can include many things. The most important thing to be noted down in description is, implied condition in sale by description is, it should be in merchantable quality. It should be in such a state that it can be sold. And also one more thing, if it is not in accordance with the description, then the buyer can reject it. A very important thing to be noted here is, the buyer is depending on the description. He has not seen the sample. For example, the seller calls the buyer and says that, I have a car which is in good condition. It has got all the parts in the car is in a proper condition. You can drive it. You can even use it for touring purpose. So he gives a list of description. It has got these, the headlights are in proper condition, the brakes and the other spare parts, the engine, the oil, everything are well fitted. So he gives the description. On believing the description, the buyer is buying it. When does he see the goods? Only when he gets it. That is when the delivery has happened. So that is why, if at all it is not as per the description, he may reject the goods. Fine. However, he has also an option under section 13 to accept the goods by treating as a breach of warranty, breach of condition as a breach of warranty, and he can also claim damages. I told you when conditions become warranty. So he can treat it as a breach of warranty, and then, but only thing he can do is he cannot reject when he takes it as a warranty. He can only claim certain damages. That's all. Clear? Next, we have a case law for this, that is Marley versus Whip. Here, there was a sale of, there is a contract of sale of second-hand reaping machine, and the buyer has not seen it. The seller describes that it is a new machine, just a year old, and I have not used it much. I have used only for 50 to 60 acre of land. It is capable of doing very well, everything is in good condition. Then the buyer says, believing the description, he says, okay, fine, you deliver it to me. After the delivery, it was found out by the buyer that it was not as per the description which is given by the seller. Now, it was held that buyer is entitled to reject it. He can reject it. When it is not as per the description, he can reject the goods. Another example, this is another case law also. There is a person A who agreed to B to supply certain new Singer car. The buyer found that after taking a car, it is not new, and there is some mileage which he saw the mileage also. Then from that he could determine that yes, the car was used. So what is it? It is a breach of contract, and now the seller is liable to pay compensation to the buyer, and the buyer can reject the goods also. So when I was telling about the description, I even mentioned that the description also includes date of shipment. So if at all the date of arrival to the destination is given as a part of the description and it is not fulfilled and it is not supplied to the buyer at that particular time, it again amounts to breach of description. We have a case law for this, that is McParenson Train and Company Limited versus Howard Rose and Company Limited. Howard Rose and Company Limited, I'm sorry. So in this case, there was a contract of supply of Australian quick frozen peaches. It was for a peaches. In one of the clause it stated that the shipment and the destination was approximately by June 8th. But what happened in real case is the ship arrived to London somewhere on June 21st. So now what it is way too delay, right? So the description said that it will be arriving at June 8, approximately June 8. But where is June 8 in June 21st? So by those words it said, right, due to approximately by June 8, there was a condition, that was one of the condition of contract, because of which the seller made the condition and there was a breach, and therefore now the buyer can reject the goods. Clear with this? Your description includes many things. It may be quality, fitness, date of delivery, how it is delivered, packaging. It includes many of the things. Basically, your description. And the next thing is implied condition in sale by sample as well as description. Now we are taking into two things into consideration. We are saying sample plus description. So when you are buying the goods, when you look at the sample and when you are as well as you are getting a description of the product or the goods, it should correspond. Both should correspond to each other. It is not that the sample shown is the bulk of goods corresponds with the sample but not with the description. It cannot happen. It has to, both has to correspond each other. If at all there is some difference between the sample and the description, it is not acceptable. That forms a fundamental breach of condition. So whenever if the sample and description does not correspond to each other, what is it called? It is fundamental breach of condition. Then the buyer is entitled to reject the goods. Let's go to a case law and understand this in a better way. Nicole versus Cots. So here there was a contract for sale of foreign refined oil. And the samples were shown, the samples were same. But what had happened, this particular oil was adulterated with another oil. That is oil called hemp oil, HEMP. oil. So it was adulterated with other oil. So when it was found out, it was held by the court that oil is not as per the description. You showed the sample, the same color, same, no, the quality, everything is same. But what had happened? The description was different. It was mixed with some other oil. So it was held that buyer was entitled to reject the goods since it did not correspond with the sample as well as description. Here it did not correspond with the description. These are the first three implied conditions. Then now we will be learning, before going to the fourth implied condition, we have got to learn something about caveat emptor. What is this caveat emptor? Maybe you have heard of this term. Caveat emptor means let the buyer beware. Let buyer beware. That is, when the buyer is buying certain things, he has to be cautious. He has to take precautions. See, whatever his purpose is buying, I am buying this chalk for writing purpose on the board, right? So, it should fulfill my purpose. It should write neatly on the board. If at all it is not fulfilling the purpose, is the seller liable for this? As per caveat emptor, no, the seller won't become liable. So, whatever it is, under caveat emptor, it says that buyer has to be cautious while buying, since the seller is not aware for the purpose which you are buying. I mean, the seller is buying. And he is not taking an implied undertaking also that, see, whatever the purpose you are buying, if it is not fulfilled, I will be liable for that. The seller never admits that, never says that. So now it is the buyer who has to be cautious while buying. For example, now A purchases from B a horse. A needs that horse for riding purpose. But he does not say it to B that I need it for buying purpose. He simply purchases from B. And that particular horse which A is buying is not suitable for riding. It is only suitable for being driven in carriage. So his purpose is not fulfilled, right? Because of this rule, caveat emptor, wherein the buyer has to be prepared, he should have told the seller that I need this horse for riding. He would have told him that this particular horse is not suitable for riding. Now, since he has not disclosed the fact, A can neither reject the horse, he cannot say I don't need the horse, nor claim any compensation from B, because B does not know for what purpose he is buying. So he cannot claim compensation also from B. In one more case, that is Indre, Andrew, Yule and Company, Y-U-L-E and Company. The buyer, he orders for certain cloth. He does not specify for which he is buying that cloth to the seller. He has ordered a cloth, Hessian cloth, H-E-S-S-I-N, Hessian cloth. And that cloth has got a particular quality. It has some smell in that. Now this buyer, he does not mention the purpose for which he is buying. The buyer is buying that particular cloth for packing certain things. Because of its smell, unusual smell, it was not suitable for packing. There was certain smell in that, and thereby he couldn't pack it. His purpose was not fulfilled. And there was a case filed, and it was held in the court that the buyer had no right to reject the goods, even if it did not fulfill his need. Under what? Under caveat emptor, because buyer had to be cautious. So here we say that buyer has to be cautious. So we have certain implied condition, that is condition, implied condition 4 and 5, which are the exceptions to this caveat emptor. That is wherein the buyer beware, but there are certain conditions given under this point number 4 and point number 5, which says that even though the buyer gets to know the purpose of buying, the seller, he tells the buyer that yes, I am buying this for this particular purpose. So since he is knowing it and he is also dealing in that particular business from quite a long time, the buyer will be held liable. Here what we did is, buyer was not made liable, but here in this condition as well as that implied condition, we are making buyer liable. Clear with this? That is why we are going to study about caveat emptor here. Well, now let's see what is the exception. And the point number 4 under implied condition is, implied condition has to quality or fitness. So this is a first exception to the caveat emptor. So what it says that implied quality has to fitness or quality. So before going detail into this, the most important thing is, the buyer while purchasing certain goods, if he expressly or impliedly makes the seller knows that for what purpose he is buying, and also relies on the seller's knowledge or skill, and then buys a product, then the buyer becomes liable. The seller becomes liable. I'm really sorry. The seller becomes liable. I'll repeat this point once again. The buyer is buying a product and he makes the seller know that, see, I'm buying this product for this particular purpose. And also he believes in the seller and he buys it. The seller may make certain suggestions that you please buy this product. This product is very good. It is suitable for your purpose. And believing in him, he buys a product. Now the buyer becomes liable. This is condition number 1. Condition number 2 states that the goods supplied are such that it is in the course of seller's business to supply it. That is, the seller has been supplying it from quite a long time and he knows about the goods. Upon that condition also, the seller becomes liable. Clear with this? So these are the 2 exceptions again under as to the quality or fitness. So maybe I'll give you certain examples so you will get to know more about this. The case wise, priest versus lust. In this case, what happens? The plaintiff, he goes to the defendant and the defendant is a chemist. And he asks for an hot water bottle. The defendant sold him American rubber bottle and said that this bottle would stand hot but not boiling water. Believing in the defendant's words, he purchases the bottle. So, and that bottle he gives it to his wife, and his wife, she'll be using, in the course of using, she fills it with the hot water and the bottle is burst and it injures her. Now, how did the plaintiff purchase the bottle? It is upon believing the defendant that it is suitable for the purpose for which the buyer wants it. Since the bottle was not fit for which the buyer had purchased, the defendant was liable. Who was liable? The seller was liable in this case for compensation. Clear? I hope you got to know the exception to this. Here the buyer is made liable and the seller is not made liable. But in this case, the seller is being made liable because the purpose is told to him. Whom? The seller. The buyer is telling the purpose to the seller. And also is relying upon his skill and knowledge, and also the seller is dealing with those products from quite a long time. That is why the seller becomes liable. So caveat emptor, let the buyer beware. Do remember, seller is not liable. Exceptions are has the quality and fitness. There the seller becomes liable, and even in mercantile quality the seller becomes liable. I hope you are clear with this. The next case law is this. In this case, the second case, what happens? The buyer, he purchases a bun from a bakery. The bakery is quite famous. He purchases the bun from a bakery. When he was having a bite, there was a stone which got stuck to his teeth, and also due to this there was a certain swelling and infection in his jaw also. Such bun is not suitable for eating purpose. So now it shows that since it was a quite famous bakery, the buyer relied on the skill and knowledge of the seller, and believing that he bought the bun and he had it. So now who becomes liable in this case? The seller. Clear with this? So under all these conditions, as to the quality of fitness, the seller becomes liable, and this is an exception to caveat emptor rule. One more important thing to be noted is no implied condition to goods sold under trademarks or patents. If the goods are sold on trademarks or patents, what is it, ma'am? There was one case, the first case, Cantor versus Hawkins. In this case, what happens is the buyer, believing in the trademark of the goods, he orders for a smoke consuming furnace. He tells the seller that I want this particular goods for smoke consuming furnace in my brewing copper. Then when the seller supplied it, that is the furnace plus apparatus, whatever was requested by the buyer, it was found out by the buyer that it did not fit for his brewery purpose. Then it was held that since the seller supplied what was ordered by the buyer, it was ordered by the buyer. He asked for a particular product, that is under particular product, that I want this particular furnace itself. So he was not entitled to recover the price from the buyer. Clear with? He was entitled to recover the price from the buyer. Basically the seller was not made liable, because whatever was ordered, he has given it, therefore seller is not liable for this. The next case is Baldry versus Marshall. Well, when you are relying upon certain product, that is upon a trademark or patent, also plus you are also relying on the seller's skill and knowledge. Then what is the case as to the fitness of that particular product or quality of that product? Then what is it? Here in the first case, he only asked for that particular product which had this particular trademark. Now the second case, he is relying on the trademark plus seller's knowledge as well as skill. So the plaintiff, he wanted to purchase a motor car, and he approached the defendants who were dealers in motor car. The plaintiff told that he required it for touring purpose. He has disclosed it. The defendant recommended one car, Bugatti car, and he also showed the specimens, and the plaintiff ordered for it, and it was later on found that the car was not suitable for touring purpose. Now what happened? It was held that since the car was not suitable for the touring purpose, the plaintiff claimed to reject the car and also recover the money. They could reject the car and recover the money. Clear with this? Since they had depended on whom? The seller's knowledge and skill plus the trademark. In that case, yes, they can receive their money back. Clear with this? Two different situations here. Yes. So by giving this case laws, you can understand it more clearly. The next condition, implied condition, is implied condition of mercantile quality. This is the second exception to this caveat emptor rule. First exception, and also this is also and one more exception, and this is your third exception. In fact, generally it is one of the sub point here. You can make it as second exception. This is given given under section 16 subsection 2. So what is mercantile quality? When the goods are bought by description, there is an implied condition that it has to be as per the description. This further section, that is section 16 subsection 2, it further lays down certain condition where you can say it is of mercantile quality. That is, where the goods are brought by description from the dealer who deals in the goods of description, and whether he is a manufacturer or a producer or not, that is not relevant, but he is in course of that dealing, that particular business. So that becomes a mercantile quality. Let's take an example. Let's take this case law as an example and let's understand. Jacks versus Rotax Motors and Cycle Company. In this case, the defendant had ordered for 600 motor horns of varying description. So when he had ordered, he received the goods. When he received the goods, he found certain horns were dented and were not painted. It was badly polished. So defendant rejected the goods. He was very unhappy with the goods and he rejected the goods, and in fact he rejected the whole consignment itself. It was held that, then they filed a case that he cannot reject the entire goods. Then the court held that the defect and the goods had rendered the products unmerchantable, and the buyer was entitled to reject the goods or reject the whole consignment, although some pieces were defective. Even though some pieces were defective, because it rendered to be unmerchantable quality, he could reject the whole consignment. Clear with this? We'll go for one more case law, that is Shivlingappa Shankarappa versus Balakrishna and Sons. In this, the buyer had ordered for a best quality tur dal. Then it was time for delivery. When the dal was loaded, there was rains, and it got wet in the rain. By the time it reached the destination, it had become damaged due to the moisture accumulation in the tur dal. So now the tur dal could not be sold as a best quality which the buyer had ordered. So now what has it become? It is not a merchantable quality. So it is entitled to claim damages from whom? From seller. Remember, from seller he is claiming damages. According to Kivet Emptor, seller is not liable to pay damages. So these two are the exceptions of Kivet Emptor. Anyways, the condition given, if the buyer examines the goods at the time of delivery, if he is doing it, then this condition, that is mercantile quality, can be negated. Yeah? The next one is sale by sample, that is implied condition in sale by sample, that's given under section 17. We have already studied about sample, but we studied there about sample by description in the third point. Here it is only sample. What is sample? Sample constitutes a true representation of kinds of goods to be ultimately supplied to the buyer under the contract. So you show the sample. You might have seen this when you go for some provision stores. They would have kept the samples of rice, dal and all. So based on that sample, you are going to buy it in bulk, right? Same way. Depending on the sample, it is assumed that it constitutes the true representative of kind of goods that is to be supplied to the buyer. So under section 17 subsection 2, there are implied condition relating to sample. What is it? The bulk shall correspond with the same sample quality. Whatever is shown in the sample, the same thing the bulk will correspond. If not in conformity, then what can buyer do? He can reject the goods. In case if the buyer is buying the goods, what is it? It is breach of condition, right? the very condition is not, the main purpose is not fulfilled. For example, if he wants to buy some basmati rice and if he is getting an ordinary rice, is condition fulfilled? No. Then he can reject the goods. If at all is accepting it, the breach of condition becomes warranty. When the condition is treated to be warranty, we have studied it. So it becomes warranty by. Then the buyer shall have reasonable opportunity in comparing the samples with the product. He can be given an opportunity to compare it and also examine it. Yeah? And if the good shall be free from any defect, rendering it unmerchantable. So the good should be free from defects. We have a case law for this, Godley versus Perry. In this case, a retailer purchased from a wholesaler a toy, that is catapults, by seeing a sample. He examines a sample, he just looks at it and he finds no defect and he buys the toys. The retailer, after getting the goods, he sells it to a boy, and when he was playing with it, it broke into pieces due to manufacturing defect and it caused injury to the boy. Now the retailer was bound to pay compensation for the boy. Since it was not retailer's mistake, now he filed a case against the wholesaler, asking him to indemnify the loss. It was held that retailer examined the goods. That is, he examined the samples, he examined the samples, and by the sample he found out that, by reasonable examination he found out that he could not make out any defects on the toy. Therefore, under these circumstances, wholesaler to indemnify the loss of retailer. Wholesaler had to indemnify the retailer. So these are the implied conditions. We got to know about implied conditions, the implied warranties. So first implied warranty is implied warranty of quiet possession. What is this quiet possession? That is given under section 14 subsection 6 of Sale of Goods Act. In a contract of sale, it says that there is an implied warranty that once the buyer is getting the goods, for whatever purpose he has got a goods, he shall have it and he shall also enjoy the possession of it. That is his implied warranty. It means that nobody can disturb the buyer's possession of goods after he getting it from the seller. To understand this better, let's take an example. That is a case law, Niblett versus Confectionery Materials Company. What did we study here? The seller, he sells a certain tons of condensed milk to the buyer under the label of Nestle Company, which is the trademark of Nestle Company. Nestle Company trademark, he sells it. Now, further, there is a commissioner of customs who says to the buyer that if at all you want to sell this, remove the labels and then you can sell it. Then, due to that, the buyer suffers losses because there was no proper labeling. Because of the seller's mistake, he had to suffer losses. There we said that since there was a breach of implied condition, that's why he was made liable to compensate. Not only implied condition was breached, also implied warranty. What was this implied warranty? He had a right, he had an implied warranty of quiet possession. After getting here that, he had a right to have it and also sell it further and enjoy whatever he gets from those proceeds. But that was also disturbed. That is why there is a breach of implied warranty of quiet possession and the seller had to compensate the buyer on this ground also. Clear with this? The next one is implied warranty against encumbrance. That's given under section 14. See, it states that whatever the goods they are buying, that goods has to be free from any encumbrance or charge. That good should not be previously been given as a pledge, or it should not be hypothecated. It has to be free. Hypothecation is for immovable. Well, it should not be given as a pledge, or it should not be. There should not be any charges. It should be free from charges. Clear with this? So, in case if the buyer gets to know that there is some, charge or encumbrance on that particular product or goods, after entering the contract, then he can claim the compensation from whom? From the person he got it, that is from the seller. Clear with this? So, implied warranty against encumbrance, there should be no encumbrance. After knowing the implied conditions and warranties, there is something called exclusion of implied terms and condition. Whatever implied terms and condition is given by the Act, that can be excluded. There is some exclusion clause. When can be excluded? First, when there is an express agreement. When the parties themselves make an agreement that, okay, we shall exclude it. We don't want to have this particular implied condition. They say that, okay, fine, we'll eliminate one of the implied condition. If there is certain agreement like that, then yes, they can have that in their agreement. Second, in course of dealing. That is, in course of dealing between the parties. They are dealing from quite a long. So they say that for this particular good, we are dealing with this particular good. I don't think so that this particular condition, implied condition is not required. From that, they can exclude any of the implied condition or even warranty by usage. If the usage is such as to bind both the parties to the contract. By usage, from many years, this particular product has been sold and it is bought by the buyer. Sold by the seller and bought by the seller. So, bought by the buyer. So, we are doing this. Why do we need this implied conditions and warranties? Let us remove it. If they enter into such agreements, then there is an exclusion of terms and conditions. Then later on, the courts found out that in spite of excluding the terms and implied conditions, terms and condition, there was certain breach happening. So the court insisted that there should be, since it is a fundamental breach of contract, due to the exception clause which is given here, that has to be given some justice, right? In order to give the justice for the people who have been who have done a breach to the innocent parties, for that the court insisted in having this particular thing included, that is fundamental breach of contract included, so that the innocent won't be suffering any loss. So that we have a case law, that is Car Sales Harrow Limited versus Wallace. In this case, what happens? There is a transfer of second-hand car on a hire purchase basis with the condition, with a stipulation that there is one stipulation that saying that there is no warranty or guarantee that the vehicle is roadworthy, and also to its age, condition or fitness or for any purpose, and is given by the owner, which is given by the owner or implied therein. See, basically said that we are not giving you any implied condition, any warranty or guarantee about the car. Then the car was shown to the hirer. He finds the car as okay, even though if it is not roadworthy. Okay, fine. He is happy with the car and he wants to purchase it on a higher purchase basis. Then finally he asks the seller to deliver the car. When the seller delivers the car, the hirer or the purchaser finds it in a very deplorable condition. This is very bad condition. Before the delivery, when the car was shown, there were new tires fitted to the car, but it was replaced with the old tires. even 2 pistons were broken, and there were certain chrome strips around the car, or around the body of the car, which was removed. And the cost of car given by the hirer or the purchaser was 150 euros. Now he asked it back because the condition was totally different, what he saw and what he received. So it was held that in spite of exemption clause, they had certain exemption clause saying that no guarantee, no guarantee. They had certain clause, right, in the form of agreement. So in spite of there being an exemption clause, the hirer, that is, hirer is an innocent person. He has a right to reject the car since there was fundamental breach of contract. What is it? Difference in the car showed and what was delivered. So even the hirer, being an innocent party, could make the seller liable even though there existed exclusion clause. Clear with